Order. I will call Mr. Philip Hollowbone to move the motion, and I will then call the Minister to respond. There will not be an opportunity for the member in charge to wind up, as is the convention for 30-minute debates. Order, order. Mr. Philip Hollowbone to move the motion.
I beg to move, Ms Rees, that this House has considered planning policy for Gypsy and Traveller sites. Can I say what a delight it is to see you in the chair, Ms Rees? Can I thank Mr Speaker for granting me permission for this debate, and can I welcome the Minister to his place and thank him also for visiting Kettering to discuss this very issue on the 8th of February. Now, the purpose of this debate, Ms Rees, is to request to make it clear to the Minister that what we need is changes to the legislative framework for Gypsy and Traveller pitch provision, unauthorised development and licensing and management of Gypsy and Traveller sites. Now, it will be frustrating for residents in my constituency that I won't be able to go in detail in this debate about specific local sites because various forms of planning enforcement and legal action are underway. But just to highlight in passing, Oakley Park and Peasdale Hill in Middleton in the neighbouring Corby constituency, and in my own constituency, sites at Loddington, Broughton, Braybrook, Stoke Albany and Desborough. And can I also highlight controversy locally over a proposed traveller stopping site at Rothwell, which is to deal with the issue, which I know is slightly separate, of unauthorised encampments under Home Office provisions, and I appreciate that's not the direct responsibility of the local government minister who is in front of us today. But just to deal with that one first, under the Criminal Justice and Public Order Act 1994, as amended by the Police Crime Sentencing and Courts Act 2022, in section 62A, it allows a senior police officer to direct those in an unauthorised encampment consisting of at least one vehicle and caravan to leave land upon which it does not have permission to be if the local authority can provide a suitable pitch elsewhere in the area. My personal view is that a senior officer should be able to direct them to leave outside the local authority area without the local authority having to provide alternative provision. I will.
I know my constituency over the last number of years as an elected representative, I've had to deal with this in some occasions as the council had. But does the honourable member not agree that it is essential that local community planning and thereby provision goes hand in hand with the right for travellers and gypsies to have freedom to live as they culturally and historically have done, and that sensitivity is perhaps the best way forward?
Well, my honourable friend brings me on to my next point, which is that the government's planning policy for traveller sites sets out national planning policies for gypsies and travellers, and in that policy the government states that its overarching aim is to ensure fair and equal treatment of gypsies and travellers and to facilitate their traditional and nomadic way of life while respecting the interests of the settled community. My contention is that fair and equal treatment goes both ways. And in my assessment, what the current planning policy actually enables is gypsies and travellers to develop sites in the countryside which members of the settled community simply wouldn't be able to develop under the same planning regulations. And though the aim of the policy is fair and equal treatment, actually it's preferential treatment for gypsies and travellers.
My honourable friend, I congratulate my honourable friend on securing this debate. Actually, picking up on this point, there is also an unfairness within the planning system with those local authority areas which have always traditionally provided a large number of pitches, almost being penalised in the fact that they then have to almost provide so many more. And duty to cooperate or cooperation between other local authorities who have literally zero pitches means that they take on no additional pitches, and this needs to be addressed because you're asking the same local authorities to make all the provision, and this cannot be sustained.
Well, I thank my right honourable friend for that intervention, and as always, he's absolutely spot on. There's an unfairness in the system which penalises authorities who stick by the rules, who then find they have to make even greater provision for more and more Gypsy and Traveller sites going forward. Yes.
Member for giving way. Firstly, I should declare an interest as a serving Somerset councillor. Somerset Council, like all local authorities, has the power to take enforcement action where it's appropriate. However, decisions that were made by the previous Conservative administration in Somerset has left the county without any appropriate transit sites. And so, regardless of the intent of the council, the cost of developing those transit sites now, like any other planning development and home building, obviously is costing that much more. The costs involved are that much greater. And so does the honourable member agree with me that local authorities need more provision to take the action that they need to when is necessary?
The honourable lady is talking about temporary traveller stopping sites. Then, I highlighted that in my opening remarks. Under the present law, local authorities are encouraged to provide temporary stopping sites so that gypsies and travellers who have temporary unauthorised encampments can only be moved out of a local authority area if such transit provision has been made. And I would argue that should be unnecessary, that they should be required to move out of the area in any case, just like anyone else would in the settled community if they were parked up temporarily on somebody else's land.
Giving way. I know he's a fair-minded person, and could I suggest to him that actually the balance goes the other way than he's suggesting? And he might be aware of the case of Smith and Home Secretary, which was handed down yesterday, which granted a declaration of incompatibility under the ECHR, saying that there's a lack of lawful stopping places for gypsies and travellers, and unless the government increases provision, the law as currently drafted will amount to unjustified race discrimination. It's the lack of sites. For example, only 8 out of 68 local authorities in the southeast of England have identified the land needed for gypsies and travellers in their area. That's at the root of the problem, not unfair treatment which benefits gypsies and travellers.
The honourable gentleman for his intervention. As always, we totally differ on these issues, and I would argue that we should withdraw from the European Convention on Human Rights and amend the Human Rights Act, because it's simply absurd in my view that public authorities should be spending millions of pounds to develop stopping sites for gypsies and travellers. The pressure on the public purse is already enormous without adding to it.
Thanks to the honourable gentleman for giving way, and I am also in complete opposition to your long-standing views. The reality is that there is disgracefully unjust discrimination against gypsies and travellers in planning process. My honourable friends just touched on the European High Court ruling yesterday with the ACHR, and I asked the member to read the excellent research from friends, families and travellers, which clearly evidence the reluctance and failure of local authorities to ensure socially rented sites are created, and rightly calls on the government to reintroduce a statutory duty to ensure the accommodation needs of gypsies and travellers are met.
And for his intervention, he won't be surprised that I totally disagree. But perhaps to put this into context, and could I thank the House of Commons Library for its excellent briefing published today ahead of this debate. Just in context, in July 2023, local authorities counted over 25,000 caravans on gypsy and traveller sites in England. Now, this is a 21% increase in the last 10 years. And of those caravans, 26% were on public sites, 60% were on authorised private sites, and 14% were on unauthorised sites. Of the unauthorised sites, most, 83%, were on land owned by gypsies and travellers, and 17% were unauthorised encampments on land belonging to private landowners or public authorities. The focus of this debate, with particular reference to Kettering and North Northamptonshire, is the 14% of these unauthorised sites, but also where you've got authorised private sites, the abuse of the conditions that have been laid down in the grant of planning permission for them. Now, locally in Kettering, Northamptonshire Council is committed to meeting the needs of the Gypsy and Traveller community and addressing the challenges that they face. A Gypsy and Traveller local plan is in preparation, and quarterly meetings occur with interested local parish councils. And could I praise Councillor David Howes, who's the Northants Council portfolio holder for Gypsies and Travellers, and George Candler, who's the Deputy Chief Executive at Northants Council, for facilitating those extremely useful meetings, which are positive, focused on providing suitable Gypsy and Traveller provision, but also addressing unauthorised encampments and unlawful development of sites. And the suggestions I'm going to outline in the next 5 to 10 minutes have emerged from the meeting which the Minister very kindly attended in Kettering on the 8th of February, which was attended by council officers, representatives from the local parish councils. And these suggestions are about how the current law encumbers local planning authorities in effectively enforcing the system. Yes.
I thank my honourable friend for giving way and congratulate him on securing this debate. I mean, touches on a key point. Planning guidance differs. Does he not agree this is one of the problems, that planning guidance differs so much from local authority to local authority, and also how they apply it. For example, York Council, which covers my constituencies, planning guidance has been all over the place recently on this exact issue. They've been looking at expanding existing sites, and then when that hasn't worked, they've then moved to look at forcing local developers to add 1 to 2 pitches for every new development that comes forward. This is actually opposed by the local travelling community and the local communities themselves. So this policy is just not working, and we've got to find a better way of taking this forward.
Well, I'm grateful for that very useful intervention, because it's clear to me that the planning system around Gypsy and Traveller provision has so many holes in it, and it simply isn't working. It's certainly not working for his constituents, it's not working for mine. Now, a common seen pattern of behaviour, Miss Rees, is for travellers to buy a plot of land, move on at a bank holiday weekend, strip off the topsoil and have a queue of tipper lorries arrive at the site to drop off hardcore. By the end of the weekend, hard standing is down and caravans are occupying the site with no immediate action to stop. Legal wrangles then follow through the planning process for perhaps the next 3 to 4 years or even longer, with enforcement, planning applications, appeals and so on. Now, most of the unauthorised developments in my local area are dealing with Gypsies and Travellers who have purchased the land, so they're not trespassers, and it can be difficult for the local authority to evidence at which point development has actually occurred, which is sufficient to serve a stop notice. And this is particularly problematic in the early stages where no residential occupation of the land has actually started. The Minister will be aware that local councils can't serve a stop notice on the basis of something that may occur, but they need to be able to confirm permanent breach of the planning regulations. In other words, when residential occupation has occurred. But of course, once residential occupation has occurred, it's then more difficult to address, as the council is then involved in removing occupants from their home. The occupants claim they've got nowhere else to go, and it's not suitable to camp them at the roadside with young children, and this becomes difficult for the local council to dispute. And a local authority, quite rightly under the current law, though I think the current law needs to be amended, has to take note of human rights issues, protected characteristics, and so on, especially as travellers are recognised as an ethnic group in law. In addition, the submission by travellers of information, planning applications and other procedures are often only made shortly before critical deadlines, thereby further extending the period it takes to progress through the stages of the planning process, creating an extended period for issues to escalate. As a result, progress to a position where an application or enforcement notice can be considered or an appeal registered can often reach 18 to 24 months or more. And it's also well publicised that there's a significant backlog of cases at the Planning Inspectorate. The procedure for taking action against unlawful development is made harder and extended by the current requirements of the law, bringing about delays, risks and costs, sometimes really considerable on local authorities. Now, recent changes have come into effect under the Levelling Up and Regeneration Act 2023, but I'm afraid these won't have a dramatic impact on planning enforcement against unauthorised traveller sites. The Act does not, for example, address the difficulties in establishing the ownership of a site following a land transfer, the identities of the responsible persons on site, or whether the threshold has been met for a planning breach in law. So requests to the Minister include that there be a more simplified approach to discourage and manage the unauthorised development of land for the creation of Gypsy and Traveller pitches. The process of issuing stop notices and taking enforcement action should be accelerated, as well as the process for requiring information to validate and consider planning applications. And there needs to be provision for temporary stop notices to be able to be served immediately before residential occupation has started. Now, the identification of landowners could be made easier where individuals operate outside of the normal exchange of deeds and land registration. For example, why not have a legal requirement to publicly post information about the purchaser of a land at the site until the land registry is updated? This would facilitate faster identification of the landowner, with sanctions for failing to display details of ownership. In relation to those that fail to take seriously compliance with temporary stop notices, which is almost all the Gypsy and Traveller sites in my local area, why not make it a criminal offence to fail to comply with a temporary stop notice? With the potential for arrest and detention, this would make the punishment far more of a deterrent and encourage a greater degree of compliance. Why not make it a criminal offence to create residential accommodation or change the use of property to residential without planning permission? This would encourage the correct use of the planning system in seeking approval before development takes place. Fines, I'm afraid, are no real deterrent to get travellers to desist from pursuing unauthorised developments. There needs to be a better process to allow local councils to remove development and to consider the seizure of assets where a conviction has been secured and an order of the court obtained. And why not have a change to planning regulations to amend permitted development regulations which currently make it acceptable for the removal of topsoil? This creates significant local concern, and it has the potential to destroy ecological qualities of land and undermines the principle of biodiversity net gain, as the biodiversity is removed ahead of an application going in. And then we have the lack of alignment between the planning system and the caravan licensing regime. A caravan site licence can only be issued if there is planning permission in place. In terms of planning, you do not need to be the landowner to obtain planning permission. But to obtain a caravan licence, you need to demonstrate that you own the land. And this makes it difficult for licences to be issued to the correct responsible person. We need changes to the law whereby planning permission cannot be granted for a caravan site unless submitted by the owner of the land, or that the caravan licence can be issued only to those owners who have the required planning consent. In addition, specific protection should be afforded to landowners, such as farmers, who do not wish for their land to be occupied, nor do they wish to sell it, but they do so due to fear of reprisals. Such landowners may also find themselves subject to licensing enforcement for a site they do not actually manage. And can we have changes to the fit and proper person test under the Mobile Homes Act 2013 so that both site owners and directors or managers meet the test? And can we have more detailed guidance about how local authorities can enforce these measures? Could I thank the Minister for his attention? Could I thank his officials for liaising with officials at Northants Council about how such constructive changes to the law could be made? And could I welcome the Minister's response?
Gypsy and Traveller sites. Minister Livoli.
Thank you, Mrs Rees, and it's a pleasure to serve under your chairmanship. And I'd first like to start by thanking my honourable friend from Kettering for calling this debate today, for giving us the opportunity, even for just a few short minutes, to be able to talk about these important issues. But most importantly, also to thank him and his colleagues for the kindness they showed me when I came to Northamptonshire a couple of months ago at his invitation to talk about this issue. I know he works very closely with my honourable friend from Corby, and I was grateful for the attention and support and the explanation that many of the parish councils in my honourable friend's area who came to the meeting gave us the opportunity to go through this in the detail that I think it deserves, and I thank him both for, as I say, the debate and for that opportunity a couple of months ago to talk about this in the detail that it deserves. As with all issues of planning, I have to put a caveat on the front of my remarks, which is that I'm not able to talk about specific local plans or talk about specific local planning applications or indeed enforcement action against those planning applications for reasons I know honourable members and right honourable members will be aware. Planning ministers have a quasi-judicial role within the planning system and therefore must reserve comments on any individual application to that if it needs to be exercised. I know my honourable friend is not asking me for information or for my thoughts on individual applications, but is seeking to articulate his concerns about the policy in general, which I will also focus on. This is obviously a sensitive area of policy. I think it's been debated very reasonably today in the short time that we've had, but you can see the contours of a broader debate where people take legitimately different views. And so I will try to choose my words carefully, and it may be that I'm not able to go as far as I may otherwise would wish in certain areas, but I hope that it demonstrates that I'm engaging in the issue. But I will say more when I am able to in the future. And I should put on record, I have historic experience in my constituency of challenges in this part of planning policy, and so I'm aware of it from the perspective of North East Derbyshire. There are essentially three questions which we are debating today. One is planning for a suitable provision of sites for those in the travelling community. Secondly is for making sure that the application process for agreeing those sites is done in a fair and transparent and open manner. And then thirdly, if that is not the case, as is the principle across every policy, every intervention, every change, every action that is done by anybody out there, irrespective of the planning system, if there is enforcement to be taken, what is proportionate and reasonable to do. I will happily give way to the Honourable Gentleman from Hammersmith.
On that issue of site availability, can I recommend the Friends, Family and Travellers report to him, and indeed the member for Kettering, Kicking the Can Down the Road, the Planning and Provision of Gypsy and Traveller Sites in England, 1960 to 2023. That explains the lack of site provision, which is at the root of the judgment yesterday in Smith, which led to the declaration of incompatibility. Now, the Minister's had 24 hours to consider that judgment. So I wondered what his response, if the government's response is like to that, they will have to deal with that issue, that is the law at the moment, and deal with that issue which stems from the fact that there is discrimination where certain parts of the criminal law are being impacted where there isn't sufficient site provision in a particular area at the moment.
I'm grateful to the Honourable Gentleman from Hammersmith, and he's a very experienced member of the House, and I know that he tempts me to comment about a very, very recent legal case, but with the leave of the House, I will reserve judgment for us to review that, and for my colleagues to do that, and will not comment specifically on the outcome of that, as I'm sure he will understand. I just set out very quickly the position, and then just a few comments to my honourable friend's points that he's made. The government sets the legislative and policy framework, which we talked about today, within which this area of policy operates, including the NPPF, the National Planning Policy Framework, and then Planning Policy for Traveller Sites, PPTS. Local planning authorities, as has been articulated and as colleagues have indicated, there is a variance between are responsible for plan preparation and have a duty to make planning decisions in accordance with the development plans which they have adopted. The PPTS, the Planning Policy for Traveller Sites, should be read in conjunction with the MPPF, and there is the requirement to provide a robust evidence base for the actions that are taken by individual planning authorities when they are preparing for them. Now, we all know, because we spend a lot of time in debates like this, we recognise that whether it's about this area of planning policy or any others, no area of planning policy is perfect. And so the question is about how you balance the many different competing interests in the most appropriate way. There are always challenges, even in areas that are not contested. This is obviously a relatively contested area. And the question is, how do you ensure fairness in that discussion? So to my honourable friend's questions about fairness, it is about trying to work out how we balance that. And I accept and I agree that is an open question and is perfectly legitimate and perfectly appropriate for us to come back and look at these issues on a very regular basis, something that we try and do across planning and which I will continue to do within this area of planning, and why I'm so grateful to my honourable friend for having hosted me and officials a few months ago to articulate the challenges that were being experienced in North Hampshire. And I would absolutely welcome from members across the House their views and their thoughts about both the planning policy elements, the local plans and how they work or don't work, and then also how the planning application process for travellers works or doesn't work. My honourable friend has put on record many of his comments today, which is very helpful, but I would welcome any further from any here. It is the case, and I do think it is important to reiterate, that the number of pitches which have been provided in this country has substantially increased over my lifetime. In 1979, it was less than 10,000. It is now 25,000. So, according to the latest travel account. So there is a substantial increase in provision, and it is important that discussions like this do not miss that point out. And the question is, building upon that increase in provision, where is the logical extent of where we need to go, and what provision do we need to require local authorities to provide for or not to provide for? And that is why I would welcome comments from colleagues across the House in terms both positive and negative in terms of the impact that is happening in their areas, so that when we're thinking about that, as when we're thinking about all elements of planning policy, we can consider that in the round for when we bring ideas and proposals forward. And then my honourable friend talks, recognise I only have just under 3 minutes left, my honourable friend talks about enforcement, and that is a hugely important area of policy. As my honourable friend has highlighted, I do not lead on that part of the discussion, but I will certainly pass back the comments that he has made to my colleagues in the Home Office. As my honourable friend indicated, there is some movement, there is some progress, I think, that has been made, although I know he had comments about that, in the Levelling Up and Regeneration Act, which became law last year, removing the 4-year time limit for taking action against some of the breaches in planning control, doubling of the time when stop notices are effective from 28 to 56 days. And we have said, and we will return to the point that when there is intentional unauthorised development along the lines in general terms of what my honourable friend has articulated, that should be a material consideration when considering where the position has ended, and we are committed to consulting on that and how we implement it in the future within the broader policy framework. So, recognising I only have less than 2 minutes left, this is a very big area of policy. It is a highly contested area of policy, and it's one where I think from a government perspective, I think it's absolutely right that we tread very carefully in terms of our words and consider this in the round. I absolutely acknowledge that there are strong views across the House on all of these areas, and also I acknowledge that there are experiences in parts of the country which are really challenging at the moment. And that is one of the reasons why I am keen to hear views from all colleagues over the course of the months ahead, is why I'm really keen to understand, for any colleagues who have any suggestions about how we make progress, building upon this significant increase of pitches that have occurred over my lifetime, and recognising that we need to look at the issue in the round. I will certainly pass on my honourable friend's comments with regards to enforcement to the Home Office, and I look forward to continuing the discussions with colleagues from across the House on this in the future, because I think we need to look about how we get this policy right, look about how we understand and how we respond to some of the rightful challenges that have been set, but recognising that there is a balance that always needs to be struck here, and it's about learning from experiences and working out how policy can be iterated and amended over the long term to make sure it makes progress.
Thank you. The question is that this House has considered planning policy for Gypsy and Traveller sites. As many as are of that opinion say aye. Of the contrary, no. I think the ayes have it, the ayes have it. Order, order. Right, won't be long.